principles of Magna Carta are now enshrined in the European Convention for the Protection of Human Rights and Fundamental Freedoms, and in the Universal Declaration of Human Rights, described by Eleanor Roosevelt as a Magna Carta for all mankind. In Commonwealth countries, Magna Carta is treated as a statute of general application, which has been incorporated in their legislation. Thus, the Canadian Supreme Court in Calder versus the Attorney General of British Columbia in 1973 said that Magna Carta had always been considered to be the law throughout the empire. It was a law which followed the flag as England assumed jurisdiction over newly discovered or acquired lands or territories. In the case of Antunovich versus Dawson before the Supreme Court of Victoria in Australia in 2010, the judge had this to say: "Protecting people, especially the vulnerable, from unlawful restraints on their personal liberty is a fundamental purpose of the common law, going back to Magna Carta in 1297, in force in Victoria by virtue of the Charter of Human Rights and Responsibilities Act 2006. In landmark Privy Council appeal from the Bahamas on the mandatory death penalty, Bowe versus the Crown, Lord Bingham observed that the principle that criminal penalties should be proportionate to the gravity of the offence committed can be traced back to Magna Carta, which prohibited excessive amercements and, in the words of one commentator, clearly stipulated as fundamental law a prohibition on excessiveness in punishments." Lord Woolf remarked in a lecture given on the 790th anniversary in 2005, "India's very distinguished Supreme Court has the task of upholding the rule of law in the largest democracy in the world. And it is no surprise to find that court deciding that the right of a citizen to have a passport is based on Magna Carta." The place of Magna Carta in the Constitution of the United States is well known. One of the strongest and most recent affirmations of the power and reach of Magna Carta was given by the US Supreme Court in its judgment in one of the Guantanamo Bay cases, Razzle versus Bush, where it said, "Habeas corpus is a writ antecedent to statute, throwing its root deep into the genius of our common law. At its historical core, the writ of habeas corpus has served as a means of reviewing the legality of executive detention, and it is in that context that its protections have been strongest." As Magna Carta is thus embodied in the jurisprudence of the common law world, so Commonwealth principles, embodied in the Commonwealth Charter and in earlier declarations, are cited in courts across the Commonwealth. Thus, in the Supreme Court of Ghana in 2011, Justice Dotsi cited the Latimer House principles in support of his view that judges should avoid usurping the duties of Parliament, as in Johnson versus Republic. In 2014, in the Supreme Court of Tonga, where, as we have heard, the first Bill of Rights in the Commonwealth was enacted, Chief Justice Tuholaki cited the same principles in asserting the importance of preserving the independence and impartiality of the judiciary in Tuifa versus Public Services Tribunal.